My name is Nola Alloway and I'll chair this evening's events. And this evening's event is brought to you by the Faculty of Arts, Education and Social Sciences. So thank you all for coming and helping us commemorate and celebrate 21 years of history in the making since the High Court decision on the Mabo case, which we mark this evening with a public oration by Dr. Bryan Keon-Cohen, AM-QC. So before I begin, I'd like to acknowledge in the audience we have our Vice-Chancellor, Professor Sandra Harding, our Senior Deputy Vice-Chancellor, Professor Chris Coughlin, our Deputy Vice-Chancellor Academic, Professor Sally Kift, other distinguished guests including Professor Noel Lewis, staff and students of the university and members of the community. So it's probably obvious from playing around down here that in an effort to be inclusive and to open the opportunity to as many people as we could, that we've attempted to video link with our teaching sites and other campuses. So we have some colleagues there from Cairns, Mackay, and we're not quite sure if the other one was Mount Isa, Singapore or TI, but everyone was invited. So welcome everyone. And I need to let you know too that the session is being video recorded and it will be made available on the JCU site within the coming week. So informally opening the proceedings this evening, could I invite Ms Florence Onus to the podium, and Florence is going to provide a welcome to country on behalf of the Bindal and Woolgoorooka people. Thank you, Florence.
Watamoli, and welcome to the annual Mabo lecture. Mabo and others, products or agents of progress. On behalf of the Bindal people, I'd like to also acknowledge traditional owners of other sites that we're actually video linking in, and also acknowledging community and our elders here today, as well as our distinguished guests, senior management of the university, and a very warm welcome to Dr. Bryan Keon-Cohen, who was the junior counsel for the plaintiffs Mabo, Passy and Rice at the time. I'd also like to acknowledge the members of the Mabo family, Passy and Rice families, and Auntie Benita Mabo and the family aren't here, but they send their apologies to you and with you in spirit. Thank you.
So thank you, Florence, for your welcome to Bindal and Woolgoorooka country. At James Cook University, we take pride in acknowledging the original inhabitants and custodians of the land, and understand that formal welcomes like the one that you've just offered us are a sign and demonstration of that pride and commitment, so thank you. So before Dr. Keon-Cohen begins his presentation, I'd like to make a few very brief comments that I hope will throw some light on why James Cook University and our Faculty of Arts, Education and Social Sciences in particular is so committed to celebrating Mabo Day with a special lecture as close to the 3rd of June, the victory date, as is possible. For those of you who don't already know, Koiki Mabo was on the staff at James Cook University. He worked here as a gardener groundsman from 1967 to 1971. From 1973 to 83, Eddie set up and became the director of the Black Community School in Townsville. During this period, he enrolled as a student and studied teaching in the then College of Advanced Education, which was later amalgamated with our university. It was through his association with our humanities and education staff, Professors Henry Reynolds and Noel Lewis, that Eddie became interested in who owned the land on which his people lived and in native title. In 1981, he attended a land rights conference here at the university that our student union helped to organise. And from that point onwards, his interest in native title intensified. The case which Eddie Mabo pursued was one of the most significant legal cases in Australian history. The Mabo versus Queensland case overturned legal doctrine that for more than 2 centuries had supported the idea of terra nullius. It fundamentally challenged deeply embedded beliefs about how our country came into being and about land ownership. For many of us, the landmark legal decision has been rendered personal as well as political and historic, because of Eddie's important association with our staff and students and with our surrounding communities. For these reasons, to name just a few, our faculty has been committed to providing a commemorative annual Mabo lecture, which we decided would be given each year by a prominent person who has made a significant contribution to contemporary Australian society. Since 2004, the lectures have been delivered by Father Frank Brennan, Hugh Mackay, Professor Larissa Berendt, the Honourable Jenny Macklin MP, Professor Ross Garno, Professor Chris Sara, Mr Mick Gooder, Professor Henry Reynolds, and this year, Dr Keon-Cohen. Today, in commemorating and celebrating the 1992 High Court decision on native title, Dr Keon-Cohen will deliver the Mabo lecture titled Mabo and Others, Products or Agents of Progress. So I should tell you a little bit about him. Dr Bryan Keon-Cohen, AMQC, is a barrister, writer and activist. He was born and educated at Scots College in Melbourne and graduated with an LLM, LLB and a BA from Melbourne University in 1971. Thereafter, he lectured at Monash University Law School, worked with Justice Michael Kirby at the Australian Law Reform Commission in Sydney, and joined the Victorian Bar in 1981, where he still practices. He was junior counsellor for the plaintiffs throughout the Mabo litigation, 1982 to 1992, has acted for claimants in many native title and immigration matters in the Federal Court, has appeared in the High Court in significant constitutional, native title and refugee matters, has written and lectured extensively on Indigenous rights and native title issues, and has conducted research tours in North America, Africa and Brazil. Since February 2012, Dr Keon-Cohen has been president of COIN, the Commission of Inquiry Now, a community group advocating for victims of child sexual abuse. On the 26th of January 2012, he was made a member of the Order of Australia for services to the law, especially the development of Indigenous rights. In May 2012, Bryan Keon-Cohen graduated with a PhD from Monash University following publication of his thesis book, Mabo in the Courts, Islander Tradition to Native Title, a memoir. This year, he has self-published a second edition, which he will launch tonight. On a personal note, Bryan is married to June, a lawyer. They have 3 daughters and 2 grandchildren. So I'm pleased to welcome Dr Bryan Keon-Cohen to the lecture to present the Koiki Mabo Lecture 2013. The lecture will run for about 50 minutes, Bryan says. There'll be time for questions at the end, and then we'll invite you out into the foyer for some light refreshments. Over to you. Thank you.
Vice-Chancellor, Professor Harding, Pro-Vice-Chancellor, Professor Alway, other members of staff, distinguished guests and ladies and gentlemen. Thank you for this opportunity to address you this evening and for your kind introduction. I'm a long way from home, but you've made me very welcome. I'm honoured to be invited to deliver this oration and by your attendance. The competition in Townsville this evening is fierce. For example, you could have opted for the movies and seen, according to the local newspaper, The Great Gatsby, a drama, Happiness Never Comes Alone, that's called a French comedy, The Call, a thriller, Star Trek Into Darkness, that's all about space adventures, and a thing called The Paperboy, MA 15+, called an adult drama. So I have a serious obligation. I'm required to entertain you, to keep you here. I have to be dramatic, très humoreux en français, thrilling, spaced out, and in an adult way, pornographic. This is a real challenge. Stay tuned, I'll do my best. May I pay my respects to the traditional owners of this land, the Bundjul Wulguru Lakaba people, and to their elders past and present. We shall return to these traditional owners later. My adult paper, this oration, began life as a launch by Professor Noel Luce, who I recognise in the audience, of my book, A Mabo Memoir, which you've heard about. So I apologise, you missed him and got me. I acknowledge Noel here this evening and his very helpful republished biography of Eddie Mabo. I also acknowledge, to my delight, Meb Salih, sitting before me. Meb and his family were our hosts on Murray Island during the trial in 1989 when the Supreme Court of Queensland visited the island. He was an important witness supporting the case, and he's been a good friend ever since. So thank you for coming, Meb. It's appropriate that I begin with some words about Eddie Mabo, since this oration bears his name. I knew Mabo for 10 years over the life of the litigation that also bears his name. At his funeral in February 1992, with the High Court decision still pending, I said, amongst other things, above all, I remember his deep commitment to correcting historical wrongs, some very personal, and to achieving recognition of traditional land rights of his family and his people. He was in the best sense a fighter for equal rights, a rebel, a free thinker, a restless spirit, a reformer who saw far into the future and far into the past. I'm more than happy to stand by those words this evening. However, the shape of that future, of Mabo's legacy, is a matter for constant review and debate. There remains a widely acknowledged native title gap that, unhappily for many traditional owners, 20 years on, refuses to close. Equally, my topic this evening, Mabo and others, products or agents of progress, raises deliberately some real questions. Who were these others? Did these others include not just individuals in history, plaintiffs, witnesses, lawyers, government administrators, but also institutions? For example, the High Court, the parliaments and governments of this country, Queensland's policies and laws applying to Indigenous communities, the common law of Australia. If so, what were their separate roles in this lengthy, hard-fought piece of litigation and its aftermath? Finally, 20 years on from 1992, what progress precisely are we talking about? It's appropriate at this lecture in this university, in this town, to begin with Mabo and others and other local identities. As you will know better than I, Eddie Mabo lived, worked, raised his family and studied here in Townsville, and the University Library now bears his name. Indeed, this university, its staff and students, played an important role in his life. Noel Luce and Henry Reynolds, amongst others, knew him well, befriended him and assisted him. Significantly for the Mabo case, the JCU Student Union and the Townsville Treaty Committee, of which Mabo and Luce were co-chairmen, organised an important land rights conference on this campus in September 1981. At that conference, people who subsequently became key players in the litigation delivered papers and/or spoke and/or agitated over coffee. These included the lead plaintiffs Eddie Mabo and Father Dave Passy, anthropologist Dr. Noni Sharp, who published her own account, No Ordinary Judgment, in 1996, lawyers Greg McIntyre and Barbara Hocking, and numerous supporters, including Aboriginal leader Les Meltzer, and members of the then active National Aboriginal Treaty Committee, especially Dr. Nugget Coombs and the highly regarded poet Judith Wright. The conference proceedings were published by the Students' Union. At this point, 32 years on since 1981, we can play endless but-for historical games concerning these others. For example, if no 1981 JCU conference, no case. If no papers and speeches at the conference voicing criticism of the prevailing legal dogma, most recently articulated in the Gove land rights case in the Northern Territory Supreme Court in 1970, perhaps no impetus to take on such a difficult and uncertain challenge in the High Court. Probably here tonight, a mere two or three decades on, it's too early to ask, let alone resolve, even provisionally, these questions. After all, historians argue endlessly about the true causes of just about every social or political movement. Legal change at the legislative level and, in a slower, more osmotic fashion, at the judicial level, is often sourced in these same, only partially understood social movements. The reliance in part by Sir Gerard Brennan in his leading judgment in Mabo on judicial policy, reflecting changing fundamental social norms, a reliance that triggered in 1992 the ire of conservative commentators, is a case in point. Today, proper reliance by judges on judicial policy and fundamental norms, compared to passing political agitation when deciding cases, is to most lawyers uncontentious. Part and parcel of modern judicial technique. But again, this was not always so. The short point is, lawyers also argue about judicial methodology and the criteria to apply when assessing a particular decision. Historical and legal movements are rarely as simple as isolating out and assessing the role of individuals. Take that well-known historical figure, Martin Luther. Was he a product of or creator of the forces that led the Reformation in Europe? Similar but-for questions arise for Eddie Mabo, other key participants, and native title itself. Our answers depend to a large extent on what we, looking back, consider to be significant and thus worth recording. In the latest issue of the New York Review of Books, when reviewing the history of Christianity over the centuries with its many developments, schisms and controversies, Cambridge University historian Professor Eamon Duffy says, and I quote, "History is written backwards. Hindsight is of its essence, and every attempt to characterise any great and complex historical movement is an act of retrospective construction. What is left out of the story is as significant as anything included." When it comes to the Mabo reform, I offer 3 comments. First, to my mind, a significant aspect often omitted from the Mabo story is the critical supportive role of 2 of the 4 additional plaintiffs, Reverend Dave Passy and former councillor James Rice, and the equally important, in this instance, destructive role of the influential, long-serving Director of the Queensland Department of Aboriginal and Islander Affairs, Paddy Kaloran. I shall return to them in a moment. My second comment is that too much of the voluminous commentary since 1992 is best described in my view as not retrospective construction, but unacceptable reconstruction. I provide just one egregious example. In the recent Queen's Birthday Honours, the Australian James Crawford, also of Cambridge, where he is a Professor of International Law, was awarded an AC, Companion of the Order of Australia, which he richly deserves. A week ago, 3 journalists commented in the Melbourne Age that amongst many achievements, Professor Crawford led the Australian Law Reform Commission's inquiry into the recognition of Aboriginal customary law, when the ALRC's report was tabled in the Federal Parliament in 1986. This is true. As you've just heard, I worked in the Commission from 1978 to 1980 prior to Crawford's arrival. I was mainly employed as a researcher in that very reference, looking into Aboriginal customary law, under a former Commissioner, Justice Brewster Bell, and the then Chairman, Michael Kirby. The Age journalists, however, go on to claim that 1986 report, and I quote, is now recognised as one of the foundations of the High Court's Mabo decision that recognised native title. So, should we now add additional but-for factors? Were James Crawford and/or the Commission's report crucial players that led, or were they merely caught up in, the historical forces culminating in Mabo in 1992? I say absolutely not. The historical fact is that the ALRC, while recording relevant legislation then in place, expressly excluded from its consideration the whole land rights question. I defy anybody, including the Age, to read the ALRC's report, the High Court Mabo judgments, plus the oral and written submissions presented to the Court, and find any significant reliance, indeed any reliance at all, upon the ALRC's 1986 report. I imagine James Crawford, who I actually saw in Cambridge last year, is thoroughly embarrassed by such irresponsible and factually wrong journalism. The Age owes the good professor an apology. My third comment on the Mabo reform is that when it comes to retrospective construction, what to include and what to omit, you may glean my approach by reading my book, which I'm launching tonight, not reviewing, and that it helps, I think, to examine those questions at two moments. My first is the early 1980s. By then, a convergence of forces had set the scene, had produced a sense of it was time for activists to challenge this manifest injustice through political action and or test case litigation. I mention particularly widespread criticism concerning Queensland's racist policies and laws applied to Indigenous reserves, to an international human rights agenda, and disillusionment with politicians at every level who had thrown this Indigenous land rights hot potato into the too hard basket for far too long. My second moment is a decade later. By the time Mabo number 2 was decided in 1992, further forces may, I think, be added to this heady mix. These include the emerging reformist and activist propensities of our High Court under Chief Justice Sir Anthony Mason, and legal reforms introduced through the Canadian Supreme Court in 1984 and through Australian parliaments in 1975 and 1986. More of these institutional factors later. My topic also raises the old chestnut, the role of the individual in history. If we accept that the High Court's decision of 1992 was a significant legal development in the nation's history, a watershed in race relations, did history make the man, that is, Mabo and others, or vice versa? Being a careful lawyer, I think a little of both. As to the elephant in the room, my role in the Mabo saga, I wish to be upfront and transparent. I wish to correct some serious errors in the historical record, to speak of things said to have happened involving me that actually never happened. Ladies and gentlemen, I fear many of you may be suffering a debilitating dose of that horrible disease, historical revisionism. I speak particularly to you poor souls who have seen Rachel Perkins' ABC telly movie Mabo. In it, I am shown stripping to my underpants on the beach at Murray Island. Nearby, 3 fully clothed Miriam ladies of a certain age explode in shock, horror, dismay and worse, mocking laughter. I am then depicted racing across the beach and plunging into the boiling surf. Ladies and gentlemen, the true historical facts are as follows. I know this, I was there. First, it never happened. You don't swim offshore Murray Island. Too many sharks, and if they don't get you, thick black shoals of sardines will. The point is, this was and is a richly endowed, relatively pristine and remote tropical environment populated by a strong and resilient community, the Miriam people. They were first colonised by a European power, the British, in 1879, a full 100 years after the colonisation of Australia's eastern seaboard. Thus, by the 1980s, the Miriam people's traditional culture, like their tropical environment, had suffered significant damage, but speaking generally, less cultural damage compared to many Aboriginal communities in mainland Australia. This very issue faced the Mabo legal team for a decade. Anthropologists call it continuity and change. The issue first arose as follows. At the 1981 conference at this university, as mentioned, not only was the state of the law criticised, the possibility of mounting a land rights case was also discussed. By the end of the conference, Greg McIntyre, a solicitor, and Barbara Hocking, a Melbourne barrister, held instructions in not one but 2 cases. One for the Miriam people, a second for the Yarrabah Aboriginal Reserve community located near Cairns, not far away. Ron Caston QC and I completed the legal team a month later. The Yarrabah community at that time comprised several groups that had been forced off their country and collected into a reserve under Queensland's policies and laws dealing with Aboriginal and Islander people, disparagingly referred to as Cloran's Law, or living under the Dog Act. We Mabo lawyers were thus presented with 2 possible land rights cases involving 2 Queensland communities, Murray Island and Yarrabah, located at either end of the remote, closely settled, traditional, severely acculturated continuum. As things transpired, however, our Yarrabah instructions faded away during 1982. This was because our main client was one Mr. Percy Neal. By an accident of history, he didn't wait for Mabo he pursued spectacular criminal proceedings of his own all the way to the High Court and won. Mr. Neil spat at a Yarrabah reserve manager through a fly-wire door, was charged, convicted and jailed by a magistrate. His conviction was upheld and his sentence astonishingly was increased by the Queensland Court of Criminal Appeal. Finally, both his conviction and sentence were thrown out by the High Court in 1982. In his reasons, Justice Lionel Murphy of the High Court famously quoted Oscar Wilde and concluded, "Mr. Neil is entitled to be an agitator." Thus the Yarrabah claim stalled while Mabo proceeded. We lawyers considered ourselves to be in very good company indeed. The historical what-ifs surrounding Mr. Neil, not to mention Killoran's notorious law as enforced throughout Queensland's Indigenous reserves, and the unusual judicial techniques of Justice Lionel Murphy are intriguing to contemplate. Suffice to say here that we will never know whether but for Killoran's law, the Mabo or Yarrabah cases would have ever emerged, nor the outcome had Yarrabah been pursued ahead of Mabo. One thing, however, is certain. Given the paucity of legal aid, often mentioned in my book, the legal team could not possibly have run both cases together with the necessary attention to detail or at all. I also note that never, over the decade, did Queensland seek to negotiate an outcome in Mabo. This was a full-on fight that consumed all available resources. In addition, due to the considerable cultural damage suffered by the Yarrabah group, I doubt that their evidence and their prospects of success at trial would have been stronger. But I might be wrong in that. We will never know. One of those unsolved what-but-ifs of history. However, the Yarrabah false start indicates how vital agitators are in our quest to achieve a just and civilised society. Mention of these key players, Mabo, Neil, Killoran, raises the bad King John theory of history. In particular, the role of the 5 plaintiffs and other key actors in the Mabo litigation itself. This theory asserts that what matters in history is the character and behaviour of individuals, as against ill-defined social, economic or political forces. In his well-known work, What is History?, published in 1961, E.H. Carr states, and I quote, "The great man is always representative either of existing forces or of forces which he helps to create by way of challenge to existing authority. But the higher degree of creativity may perhaps be assigned to those great men who, like Cromwell or Lenin, helped to mould the forces which carried them to greatness, rather than those who, like Napoleon or Bismarck, rode to greatness on the back of already existing forces." I note here that according to the Courier Mail, today is the 198th anniversary of the Battle of Waterloo, when the Duke of Wellington defeated Napoleon. This is indeed an appropriate day to remember the Battle of Mabo. E.H. Carr continues, "What seems to me essential is to recognise in the great man an outstanding individual who is at once a product and an agent of the historical process, at once the representative and the creator of social forces which change the shape of the world and the thoughts of men." I think much of this can be applied to Eddie Mabo, but the facts concerning the Mabo litigation are complex and sometimes get in the way of a single great man conclusion. As mentioned, one very influential but largely forgotten force opposing the claim over the decade was Queensland's Aboriginal Affairs bureaucracy and its long-term and influential director, Pat Killoran. His role in this history should not be forgotten. Patrick "Paddy" Killoran, as many here might recall, was a powerful figure in Indigenous affairs policy and administration in Queensland over 4 decades and an important witness for Queensland in the Mabo trial. He began his career with the relevant department in Thursday Island in 1948, undoubtedly assisted many communities and counted many islanders among his friends. Equally, however, Killoran's law personified the much reviled regime of control and denial of basic human rights on Queensland Aboriginal Islander reserves. Truly a contentious historical figure. He, his department and his government opposed the claim at every possible point. I cross-examined Paddy Keon-Cohen in 1989 during the Mabo trial in Brisbane. Perhaps best described as irresistible force meets immovable object. That's another story. Please read my book, A Mabo Member, chapter 13.3, pages 306 to 20. I'm still unsure who prevailed. Paddy Keon-Cohen died in August 2010, aged 88. Apparently, according to the Australian newspaper, without, and I quote, recognition or any death or funeral notice or valediction in the state or federal parliament. One of Keon-Cohen's former ministers, Bob Katter, also stated, and I quote, the latter half of Keon-Cohen's administration went far beyond paternalism and had to be opposed. Many people had their careers destroyed. Keon-Cohen's regime had become evil. At narrations such as this, should I leave out recalling Eamon Duffy of Cambridge and perhaps contentious claims that speak ill of the dead? Am I being irresponsible, unnecessarily offensive? Perhaps members of the Keon-Cohen family are in the audience. What is the historian's proper role? I reply, why not include such critical facts or opinions, provided the facts are true, i.e. supported by proper evidence, or, if an opinion, it is reasonably defensible. And if it makes any difference, I shall shortly criticise a deceased Murray Islander from the distinguished Passy family. If it matters, this perhaps at least levels the race relations playing field. Indeed, I do not rely solely upon the word of the colourful Queensland politician Bob Katter, and of course Paddy Keon-Cohen is now unable to defend his name. However, many Queensland Reserve residents during Keon-Cohen's administration would, I think, agree with Katter's criticism. Whatever the historical truth, this statement was made. I choose to refer to it this evening, and unquestionably, widespread dissatisfaction with Queensland's administration of Indigenous reserves was a major contributing factor leading to the Mabo challenge. And the fact also is that pressure applied by at least one Queensland departmental officer, being a Murray Islander no less, upon the plaintiffs to withdraw, nearly undermined the whole case. I shall return to this sorry affair in a moment. If I may paraphrase Federal Court Justice Howard Olney when dismissing the Yorta Yorta native title claim in 1998, by 2010, the tide of history had surely washed Paddy Keon-Cohen and the Aboriginal reserve regime that bore his name well and truly away. Let me now, however, return to the pristine beaches of Murray Island, a great spot for skinny dipping, and the alleged facts of history as depicted in Rachel Perkins' otherwise commendable Mabo movie. My second complaint of revisionism or respective reconstruction is that the magnificent physique demonstrated to those lovely Miriam ladies, and now to the world via TV screens, and I'm told in-flight entertainment programs, belongs not to me but the accomplished Shakespearean actor Ewan Leslie. He is a very talented man. He played me much better than I could play me. In any event, said physique is but a shadow of my former physical glory. Now that is a fact of history. There's no way anybody here can deny it. If you can, you know far too much intimate detail and you're gagged forever. The point is, the concept itself, history, i.e. recording relevant facts, as mentioned, clearly lies in the eye of the beholder. To quote Carr again, history is a continuous process of interaction between the historian and his facts, an unending dialogue between the present and the past. The historian is part of history. The point in the procession at which he finds himself determines his angle of vision over the past. My angle of vision is essentially that of a lawyer, albeit with a BA degree that included a major in history from Melbourne University, that other place down south that you may have heard of, writing a decade or two after the events recorded. My approach, my selection of significant moments worth recording, is set out at length in my book, which I find myself now launching. I'm acutely aware that in terms of writing objective history, which involves not only facts but crucially interpretation, I was deeply involved as I was a participant in Mabo, and thus on one view am compromised. On another view, I am uniquely qualified. Many participated, but nobody participated precisely as I did, and thus to that extent, self-evidently, could not write the book I have written. Thus the book is entitled a memoir, not history. This form of history, however, has its own peculiar validity. All that aside, for what it's worth, I think that the Mabo litigation arose when various tectonic forces were moving and shifting the social, legal and political landscape in Australia. I refer to 9 factors that E.H. Carr, I suspect, would accept as causative forces. Without some or all of these, I very much doubt that we would be here this evening. First, as mentioned, was the widespread criticism of the Bjelke-Petersen government's legal and administrative regime involving gross denial of human rights on Aboriginal and Islander reserves in Queensland during the late 1970s and early 1980s. Second, the reforms of the federal Whitlam government of the 1970s, particularly the enactment of the Racial Discrimination Act in 1979. And I pause to note that Act has led to High Court litigation involving alcohol matters and Palm Island, which will be handed down tomorrow in Canberra by the High Court. I note that in 1985, the Bjelke-Petersen government passed a law specifically designed to kill off the Mabo case, that we challenged that state legislation as unconstitutional, being in conflict with the Federal Racial Discrimination Act of 1975, that the High Court upheld that challenge by the slimmest of margins, 4-3, and had that challenge failed, end of the litigation, back to Yarrabah and Mr. Percy Neal. Third, the arrival of the reformist High Court led by Sir Anthony Mason, plus its release from the strictures of English precedent, finally achieved by legislation in 1986 through the Australia Act. By that and prior legislation reaching back decades, all appeals from all Australian courts, state and federal, to the Privy Council in London were finally barred. Thus, but for those reforms, after 3rd of June 1992, the Queensland government, had it been so minded, could have sought to reverse the decision by going over the top, i.e. by appealing the High Court's decision to the Privy Council in London. In the sweep of legal history, had Mabo No. 2 been decided a mere decade or two earlier, it might have been reversed in London by English judges, considering the mix of legal, historical and social issues triggered by the case from their great distance and from their very different perspective. At another more case-specific level, I add the following. Fourth, the fact that counsel for the unsuccessful Gove case plaintiffs, Ted Woodward QC, back in 1971, carefully decided not to appeal that failure from the Northern Territory Supreme Court to the High Court. He feared that as the High Court was then constituted, he might achieve a dangerous adverse precedent. His decision in hindsight was very wise. I note that today's High Court is again a very different tribunal to that of the 1970s and to the Court of Chief Justice Mason in the 1990s that decided Mabo. In this sense, Mabo's timing was exquisite. Fifth, the availability and dedication beyond the call of duty to the plaintiff's cause of the brilliant legal and personal skills and financial support of the late and very great Ron Caston AM QC. I say without hesitation, without his dedication, forensic skills and high standing before Australian courts, Mabo would probably have failed at several points over the decade. Sixth, thorough instruction in English provided at Queensland taxpayers' expense by the Queensland Education Department to the Miriam people over many decades, including to the youngster Eddie Mabo on Murray Island during the late 1940s. This instruction was provided in the form of a Scottish schoolteacher, Robert Miles, with whom Mabo lived for a period, and I'll explain why later. Seventh, the construction, also at taxpayers' expense, of an airstrip on Murray Island in 1978 and a single public telephone booth. A feature of Queensland's administration of Islander communities since 1879 was controlling movement and communication to and from the islands, thus keeping islanders ignorant about and isolated from the outside world. Access to Murray Island during the 1970s was effectively limited to a department-controlled barge, the Belvedere. Without 20th century developments such as a phone and an airstrip, we Melbourne lawyers could not have visited the island, due to time and costs involved, to gather evidence. Nor could the Queensland Supreme Court have flown to the island in 1989 to hear that evidence. Without evidence, no case. Eighth, the 1981 Land Rights Conference discussed above, which triggered the challenge and at the same time brought the plaintiffs, their supporters and the lawyers together. My ninth, I say immediately, is perhaps a contentious inclusion in this illustrious pantheon of but-for historical causes, perhaps a trifle cheeky, since it involves on one view an all-out attack on the Queensland legal profession. I refer to the existence until its removal in 1989, which required a High Court challenge resisted by the Queensland Bar Association, of not the well-known rabbit-proof fence, but a rugby state of origin equivalent. This legal fence was designed to keep out irresponsible, trouble-making southern lawyers. A non-Queensland state of origin lawyer pest infiltration control regime. This protective barrier of restrictive rules was introduced by Queensland legal authorities and their political mates to protect Queensland lawyers from competition from all others. That is, to make it extremely difficult for non-Queensland, read Victorian Mabo counsel, to appear in Queensland court absent extravagant residential and other qualifications. This threat to us Melbourne lawyers' continued involvement was, however, after some anxious discussion, circumvented by a ruling given by none other than the then Chief Justice of the High Court, Sir Harry Gibbs, a distinguished Queenslander, early in 1986. His Honour resolved this question on the basis that the case was commenced in 1982 in the original jurisdiction of the High Court. Thus, when the matter was remitted from that court to the Queensland Supreme Court for a trial of facts, that trial attracted federal jurisdiction. Thus, the restrictive Queensland regime that made it virtually impossible for out-of-state counsel to appear in Queensland's courts until 1989 did not apply to us Victorian barristers in Mabo. Queensland is a peculiar place sometimes, but for this ruling by Chief Justice Gibbs, who knows? And you think my reference to irresponsible, trouble-making southern lawyers is a trifle emotional? Let me add, when introducing the Queensland Declaratory Act to Parliament in April 1985, an act designed to kill off the Mabo case prior to it even reaching a trial, the responsible Minister, Deputy Premier Bill Gunn, offered amongst other insults the following in Parliament. Quote, "The Islanders were led by two Melbourne University do-gooders, a Queen's Counsel called Castan, spelt with a K, and a person named Keon. They were leading the Islanders up the garden path." I repeat my response set out in my book at page 95. Clearly, accuracy and common sense were not prerequisites for high office in Queensland, nor was such standard expected in the Parliament. I, for one, strenuously object to half my heritage, the paternal Cohens, being gratuitously declared as non-existent by anybody, let alone an ill-informed Queensland politician. But then, whenever Indigenous issues were raised, the Bjelke-Petersen government was never one to allow inconvenient facts to inhibit comfortable ideology. Be that as it may, I'm sure that if Ron Castan were here, he would join me in saying, just as Justice Lionel Murphy said of Mr Neil that he was entitled to be an agitator, we too were and are entitled to be do-gooders, and we remain proud of that status. As I said at the outset, it's always a pleasure to come to visit Queensland. Clearly, Queenslanders should read my book. My next observation about historical revisionism, to return to my frantic frolic on the beaches of Murray Island, is that not everything that Eddie Mabo or his fellow plaintiffs or his lawyers did on Murray Island, or in the name of the Meriam people, was welcomed by the residents. Indeed, some of our conduct caused them considerable astonishment, even anger, and it seems much laughter, at least amongst the ladies of a certain age. For example, as I record in the book, the claim itself was strenuously opposed by some senior families on the island. More than once, siblings, brothers, opted for one side or another and gave evidence for or against the claim, especially opposing many of Eddie Mabo's personal land claims. As Noel Luce records in his book, Mabo's long absence from Mer sometimes found him out of step with those who had remained behind. They had apparently accepted the Queensland government's appraisal of him as an urban activist, a troublemaker, a friend of Reds, and a non-Christian. One could not say that throughout the decade-long litigation and beyond, the Meriam community as a whole constituted a united and irresistible historical force supporting the recognition of native title on their island. Far from it. The point is, there were winners and losers in this as in any other hard-fought litigation. As to the fate of our individual in history, this fractious background makes the determination of the plaintiffs, especially Mabo, Dave Passy and James Rice, and given their sometimes isolated stance, all the more admirable. As is well known, the irony and tragedy is that Mabo himself lost his claims, and it might be argued to that extent his significance in history. I have no hesitation in saying that such a conclusion would be factually wrong, not to mention unfair. The larger point is, 20 years on, all sides now agree that hard-fought forensic battles, indeed the use of formal court processes at all, are entirely inappropriate for assessing and determining native title claims. A better way is needed, and significant reform, I believe, 20 years on, is now overdue. Let me now examine a little further the critical role of truly important individuals, the plaintiffs, in this historic case. And finally, briefly overview the past 20 years of the Mabo legacy and suggest some much needed law reform. Eddie Mabo was, of course, but one of 5 original plaintiffs named in the writ issued in the High Court on 20 May 1982. These were Eddie Mabo, his elderly aunt Seluia Mapo Salih, former Murray Island Council Chairman and respected elder Sam Passy, his younger brother the Reverend Dave Passy, an ordained Anglican minister, and former councillor and teacher James Rice. During the ensuing decade, Seluia Mapo Salih died in 1985 prior to the trial commencing and thus had little involvement. As mentioned already, and as the Mabo film depicts, the plaintiff Sam Passy was spoken to and influenced by at least one officer of the Queensland bureaucracy. This was his elder brother, George Passy, a lifelong teacher and administrator with the Education and Aboriginal Affairs departments. This done on instructions from above. This conduct was without doubt a contempt of court, for which in appropriate cases you can be jailed, and takes us straight back to the already mentioned Department Director Paddy Kaloran. There is no property in a witness, but seeking to suborn or influence a party to litigation in the conduct of his or her case can amount to a serious criminal offence. Sam Passy thus withdrew as a plaintiff and later suffered a mild heart attack. He gave limited evidence on Murray Island supporting the claim, while also opposing Mabo's traditional adoption and inheritance. He did not rejoin as a plaintiff. He died in 1990 with the case still proceeding. George Passy also died in 1990. Sam's younger brother and fellow plaintiff, the Reverend Dave Passy, was also pressured by his elder brother, George. Dave withdrew with Sam, but was subsequently readmitted as a plaintiff, despite strenuous Queensland opposition by order of the trial judge, Justice Martin Moynihan. The Reverend Dave gave valuable evidence supporting the claim, and in the final result, achieved strong factual findings from Justice Moynihan about his traditional land rights on Murray Island. Only he, of all 5 plaintiffs, remains alive today. He resides on Thursday Island. Last but not least, James Rice, to his great credit, resisted pressure again from George Passy to withdraw, persisted throughout the decade, gave extensive evidence in Brisbane, and also achieved strong findings of fact. He died in 2008. But for the courage and persistence of Dave Passy and James Rice, this case would, I believe, have certainly failed. Let me explain. I often encapsulate Eddie Mabo's role in two succinct propositions. First, without Eddie Mabo, no case. Secondly, if only Eddie Mabo, the case would almost certainly have failed. What does this mean? As to the first proposition, Mabo and Reverend Dave Passy both gave initial instructions, as mentioned, at the Townsville conference in September 1981. But from the beginning, as referred to in my speech at his funeral, Eddie Mabo was the driving force, the dedicated plaintiff, the go-to man for instructions. He lived in Townsville, here, with a phone. The essential interface, being fluent in English and in Merriam-Mer, between the two radically different cultures at play, and between us lawyers and our clients and witnesses. Supported by his lawyers, he was the man who explained each world to the other. In particular, he explained the Australian legal maze to the Miriam witnesses and convinced them to follow his example, that is, to stand up against the Queensland government and bureaucracy, which had governed every aspect of their lives for generations. This was a very significant break and a courageous move. I pay tribute to all the Miriam witnesses who spoke out, and many of them made a difference. Mab Saleh amongst them. They are all listed at Appendix 25 of my book, being witnesses for both the plaintiffs and Queensland. I am sure all of these Miriam witnesses had the best interests of future Miriam generations at heart and spoke the truth as they knew it. It's just that those supporting Queensland objected to many of Mabo's personal claims, and second, had different ideas about where their future lay. As to my second proposition, if only Mabo case dismissed, unlike his surviving co-plaintiffs Dave Passy and James Rice, Mabo's evidence was entirely disbelieved by the trial judge. Thus his claims to about 40 garden and village areas and on the island and to fish traps offshore were all lost at trial. The trial judge, Justice Martin Moynihan, on the evidence before him, considered Mabo had exaggerated his traditional entitlements. Most significantly, His Honour also concluded that Eddie Mabo was not who he said he was. Thus, that is, he rejected Mabo's sense of self. His Honour determined that Mabo was not adopted Island Way, as Mabo claimed, from his biological parents to his adoptive father, his mother's brother, Benny Mabo. Thus he did not, the judge found, under custom or tradition, nor under Queensland law, inherit Benny Mabo's traditional lands, which he had claimed during the trial. I disagreed with these no adoption, no inheritance rulings, but my views did not matter. What mattered were the findings of the trial judge. In this sense, at this point, if only Mabo, case dismissed. Like that other agitator, Percy Neal of Yarrabah, his historical moment seemed to have been lost. Mabo, however, and this marks the man, after the initial shock and great disappointment, not to mention disgust with the white man's system of justice, rose to the occasion, overcame his personal loss for the greater good, and secured his place in history. This was, I think, another personal triumph. This occurred as follows. After reading the trial judge's determination over Christmas 1990-91, Ron Caston, our instructing solicitor Greg McIntyre, and I, as Caston's junior, faced a crisis, a real procedural problem. Given these trial results, what to do next? Should we proceed straight to the High Court, relying upon the findings secured by the two successful plaintiffs, Passy and Rice? Or should we appeal Justice Moynihan's rejection of Mabo's claims to the Queensland Court of Appeal? After much anxious consideration, we lawyers bit this difficult strategic bullet and advised our client, do not appeal your personal rejection. We reasoned, first, the prospects of success of such an appeal were uncertain. Second, we could be stuck in the appeal process for years and lose momentum in the main game. I note also that, unknown to us all in January 1991, Mabo would die 12 months hence. Thus, on this basis alone, given the time delays in appeals, any appeal launched in his name would die with him. Last, to be brutal, we lacked legal aid to support any such appeal. We thus advised Mabo and the other surviving plaintiffs, Passy and Rice, that they should allow the case to proceed directly to the High Court for final argument on the ultimate legal issues, relying solely on the successful personal land claims of Passy and Rice, being claims based on Miriam custom and tradition. To his credit, Mabo accepted this advice, as did Passy and Rice. The case thus proceeded to Canberra in May 1991. Mabo remained the lead plaintiff. Again, after much anxious thought in Caston's chambers, we didn't want to lose time and momentum before the court in an unseemly squabble about whose name historians should record. And the rest, as they say, is, well, history. But in making the decision he did, in allowing the case to proceed, truly the man made history. The Miriam people and the nation, I believe, should recognise Mabo's vision and concern for the greater good, not just personal gain. The tragedies, however, remain, and they are two. First, Mabo lost his personal litigious battle, as mentioned, but through an inspired act of self-denial made a major contribution to winning the war. Second, he died, aged just 56, of cancer in a Brisbane hospital in January 1992, just 6 months prior to seeing ultimate success in Mabo. Perhaps he did see it all from above. But over these past 20 years, truly his spirit and achievements live on. So, what of the case's legacy over the past 20 years? In my view, and there are many views on this topic, progress has been achieved in the arenas of native title and national reconciliation, yet much remains to be done. One view that I respect, and that accords with mine, was expressed a month ago on the 17th of May by Justice Peter Gray upon his retirement from the Federal Court after 29 years' service. Much of that was occupied in the native title jurisdiction. In his retirement speech, His Honour spoke not of progress, but lost opportunity. He said, and I quote, "The biggest disappointment in my career has been to see the opportunity given to us by the High Court in the Mabo case squandered. The concept of native title has been reduced to something of little practical significance by judges who have been unable to understand, and legislators who have been consciously averse to, the vital relationship between people and land in Aboriginal traditions." His Honour added that a future generation of Australians would have to devise a new native title system that, and I quote, "recognises and respects the rights of our Indigenous peoples and returns to them a measure of control over what, but for colonisation, would have been indisputably theirs." His Honour here poses both a serious challenge to young agitators and the ultimate but-for historical question. That is, but for colonisation, no need for Mabo in the first place. This, however, glosses over the complexities of colonisation and the potential for British law to recognise from day one of extension of sovereignty Indigenous traditional rights to country. The brutal fact is that compared to equivalent British colonies that received, like Australia, the common law of England, we have opted post-1788 and post-Mabo for the most restrictive recognition regime of traditional connection to country of all. Indeed, the Mabo principles, with all their potential referred to by Justice Gray, were established by equivalent cases in the USA in 1826, New Zealand in 1847, Nigeria in 1921, and Canada in 1973 and again in 1984. Australia has fallen well behind best international practice in this area, which remains central to reconciliation. So, where are we at and where are the failings? I offer here a brief snapshot of a complex, still developing jurisdiction. From the 1st January 1994 to March 2013, 222 determinations of native title have been registered. Of these, 174 record that native title exists in whole or in part. 48 that native title does not exist. Importantly, 73% of these determinations were made by consent, i.e., a bruising contested trial was avoided. These 222 registered determinations cover 1.7 million square kilometres, or 19% of Australia's land area. But agreement making has proven to be the real jewel in the native title crown. As at 15 March 2013, 737 Indigenous Land Use Agreements, or ILUAs, have been registered, covering 22% of Australia, plus 6,000 odd square kilometres over sea areas. In addition, about 2,500 agreements associated with native title determinations or negotiated under the Future Act regime have been reached with mining companies and others wishing to access and use claimed land. All this delivers real benefits to communities. However, as always, there is a downside. Many communities, especially in closely settled areas around the continent, have suffered so much dispossession and cultural destruction since 1788 that they cannot now access the benefits of Mabo and the Native Title Act reforms. The burden of proof required by the Act and judicial interpretation of it is simply too onerous for many claimants. The community at Yarrabah near Cairns and the Townsville traditional owners are but two of many examples. For them, Mabo has delivered not only next to nothing, but often bitter disappointment. This is the lost potential, the squandering of opportunity presented to our legislators by Mabo that Justice Gray and many others now complain of. 20 years on, agitation is growing to reform the Act in an effort to address this retreat to further injustice. Currently, the Commonwealth Government has made a reference to the Australian Law Reform Commission to, in one sense, pursue what it declined to do in 1986, that is, review the Native Title Act. At the same time, the government has introduced legislation by way of proposed minor reforms to that Act. In my view, these do not go nearly far enough if Mabo benefits are to be delivered to Indigenous communities most affected by colonisation. That is, the communities most deserving of some recompense, but least able to access the native title regime. The most important reform currently proposed would enable parties to agree to disregard the historical extinguishment of native title in environmental areas such as national parks and Crown reserves. In my view, this proposal points in the right direction, but is entirely inadequate if the denial of recognition and/or compensation to those traditional owners most impacted is to be corrected. A more radical approach, a genuine attempt to correct current injustices, develops this disregard extinguishment concept to its logical conclusion. That is, reverse the onus of proof. Here, first, all parties and a federal court judge would need to be satisfied that a current claimant group descends from the original 1788 inhabitants of the claimed area. Second, all sides should then accept that the claimant's connection to that country and traditional rights to land have continued to current times. The respondents, e.g. governments, mining companies, would then bear the onus of proving that that assumed title had been lost, e.g. by extinguishment. Such calls have been made by now High Court Chief Judge Justice Robert French, Paul Keating, Lois O'Donoghue and others. Under this scheme, Townsville's traditional owners would have a reasonable chance of successfully claiming or claiming compensation for, example, Crown reserves, or receiving fair compensation for alienated land, e.g. this university. My second suggestion is constitutional reform, which extends the above logic to the constitutional arena. Current proposals are circulating following a report in January 2012 of a panel on constitutional recognition of Indigenous Australians. Here, I would advocate entrenching into our Commonwealth Constitution the recognition of traditional land rights, as was done in Canada 30 years ago. Section 35(1) of the Canadian Constitution, introduced in 1982, states, "The existing Aboriginal and treaty rights of Aboriginal people of Canada are hereby recognised and affirmed." Full stop. I pause to note that since 1982, Canada has not sunk beneath the Atlantic nor Pacific Oceans. Likewise, such a proposal like Mabo itself will not only not wreck Australia, we would all benefit. It should be included in the current discussion on entrenching Indigenous rights into our Constitution. In this ongoing search for land justice, younger generations, black and white, have and continue to gain strength and inspiration from Indigenous leaders such as Eddie Mabo, the Reverend Dave Passy and James Rice. All three played pivotal roles in the Mabo story and leave a powerful legacy that continues to shape the native title debate today, and I anticipate into the future. The endeavours of current agitators will, I hope, also secure throughout our nation the sentiment that the presence amongst us and the survival into the future of Indigenous traditional culture and communities is a wonderful privilege, not just a problem. Certainly that has been my experience acting as a barrister over these past 30 years. I wish these young agitators well. I now have the awesome pleasure of declaring my book launched. Please enjoy. Thank you for your attention.